Welcome to Penn State Dickinson Law's Profiles and Leadership series. My name is Daryl Lim. I serve as the H. Leddy Montague Junior Chair and Associate Dean for Research and Innovation at the Law School. This series offers an opportunity to glean insights from top leaders. In each episode, we invite these leaders to reflect on their journeys and share skills, core values, and qualities that make them the leaders they are today. We're very pleased to welcome Dr. Klaus Grabinski. Since November 2022, he has served as the President of the Court of Appeal and Chairperson of the Presidium of the Unified Patent Court. President Grabinski is the most senior judge in this Penn EU court and is playing a crucial role in the harmonization of UPC case law. Prior to being appointed to his current position, he served as a judge at Germany's highest court, the Federal Court of Justice. Before that, he was a long-serving judge on the bench at both the Düsseldorf Regional Court and Düsseldorf Higher Regional Court, two of Europe's most important courts for patent infringement disputes. Welcome.
Thank you very much, Daryl. It's a pleasure to be on the program.
Let's start with your background and tell us about your time at the universities of Trier, Geneva, and Cologne, and how these experiences shape your legal career.
Well, that gets us pretty much back into time. So quite some time ago in the 80s, I started studying at Trier University, a rather small place, because I thought this would be a good idea to not to be in the very big places. And Trier is a very nice city, small university, oldest city of Germany, and they have excellent white wines there. So I enjoyed being there for 2 years. But I always had the idea that I wanted to study abroad, even before graduation. And so I then continued my studies in Geneva in a French-speaking environment. So actually, Geneva is a mix of French, English, and also German language. And at the same time, I could continue my study in German law, but of course also get first ideas on Swiss law, but also international law. So that was a wonderful year. And I used the time also to learn skiing, which I continue to do until today. And then I, of course, had to get back to serious business, meaning to prepare my first state examen, which I did at a bigger university, one of the biggest in Germany, Cologne University, where I passed the state examen in 1988.
So, a few follow-up questions. What's your favorite white wine?
Coming from the Trier region is the Riesling.
It's still your favorite?
Yes, yeah. Riesling is a bit a dry wine, but I like it very much. It goes perfectly well with particular fish, but also other dishes.
So, French versus German, and Geneva, which is in Switzerland. What are some of the main differences between how the three legal systems approach IP or the law in general?
Yeah, well, I would probably draw the line between common law and civil law approach. Of course, there are differences between German and French approach as well, but generally, I think similarities are more common than with regard to common law. And of course, when you think of IP law, I guess procedural law really makes a difference. Not that much substantive law. I think substantive law is more or less the same in both systems, but procedural law makes a difference.
Which aspect of procedural law?
Civil law is front-loading, which means you have to submit all the facts of the case, evidence, everything in writing. And then usually you have rather short hearings. Can be 1 day, it can be just 1 hour, depending on the case. While, well, at least the classical model in common law is that you have hearings for a couple of days, just and only prepared by a kind of skeleton argument. So I think that's the main difference.
And between the Swiss legal system, the German legal system, and the French legal system, objectively speaking, which is your favorite?
Well, I really know only the German system, so it's difficult for me to really compare the system. What I like with the Swiss system, and which probably doesn't come as a surprise, is that in particular in patent matters, they are very much focused on finding a settlement. So, which is different from the German system, where you get a judgment at an early point of time, maybe after 1 year, in an infringement only proceeding, which then is maybe the basis of an out-of-court settlement. That, I think, is different approaches, which will be better for that particular scenario, and the other will be better for another scenario. So that's then for the parties, upon advice of their lawyers, patent attorneys, to decide.
And you mentioned you go skiing. I know you also like, is it hiking or mountain climbing?
Well, it can be both. It can be both.
Both. Tell us about that. When was your last trip?
My last trip was in last year in summer, and I climbed. Of course, I always go when it gets really difficult or technical. I climb with a guide. That I would not dare to do it on my own. So I did this with a guide, and I climbed the Piz Bernina, which is technically, at least for my level, it was quite challenging. And this year I plan to go to Bolivia and do but more hiking, but on high altitude there. So that the challenge is a mountain of 6,000 meters altitude, and we will see whether it will work or not, because as always, when the weather conditions are not good, you can't make it, and then you have to stop, and then it's like it is.
You know, I think if the President of the United States wanted to go mountain climbing, the Secret Service might say, please rethink it, because we all depend upon you. Do your colleagues look at you and say, please rethink it, we all depend on you?
I don't know. I guess they are quite relaxed when I come back and see me coming back from these trips. But of course, I do I try to avoid unnecessary risk, of course.
What's your favorite mountain to climb?
Oh, that's difficult. There are a lot of nice mountains all over the place, but when I climbed the Kilimanjaro was quite an experience.
What made it an experience?
Yeah, well, maybe
what aspect of it?
Yeah. It was the change of nature on the way up to the top. So it starts in a jungle, and then it gets more rock-like with a lot of stones, and then the final effort was really a climb or a hike during the night to get to the ridge of the volcano, and then getting really to the highest point, the Uhuru Peak. So that is all quite a challenge. And then I was so exhausted, I thought I will never make it back down. But then the experience was, the more you got down, your forces came back, and that was also a nice experience.
So in your life, which came first, patent law or becoming a judge?
Becoming a judge, definitely, because I only learned about patent law when I was a judge.
So tell us about your journey to becoming a judge. So you finish school, and then what happens?
Yeah, well, then it's the German system provides that you do a kind of mandatory traineeship for about 2.5 years. So you assist a judge, you assist a prosecutor, you assist a lawyer, you assist in the administration, and then you pass a second state examen. And that then you have to take the decision about what to do now. And you have different options. So you can become a lawyer in a law firm. You can become a public notary, but also you can become a judge. Of course, also a bit depending on the results of your examen. And I really thought seriously of becoming a lawyer, but also an academic. But then at the end of the day, decided that I want to become a judge. And then I started in a court that was dealing or had competence in criminal and civil law matters. So it was the Regional Court of Düsseldorf, but without any idea of becoming a patent judge. But what I did not know, but that then became apparent very soon, is that this was the most busiest court at the time dealing with patent litigation. And just after half a year, the president asked me whether I want to join the patent panel, which I said yes, but with some reservations, because I was not sure that I could deal cases that are so much technology related. But at the end, after some experience, after half a year, I started to like it and feel well practicing it.
Changed your life, that one invitation.
Yes, that is definitely. But it's normally how a career or a development in professional life works. You cannot plan everything. You have to be open to invitations, to things that happen, and then be reactive to it. And that at least was, I always tried to be open to opportunities that are on the way, and then take it or not. But of course, normally opportunities are opportunities, so better take them than leave them aside.
So looking back, looking back, how different would your life have been if you decided to become an attorney or a law professor?
Yeah, well, when you say attorney, actually, I had some discussion with one of very prestigious law firm in Düsseldorf at the time. And there, the idea was that I should work in the field of merger acquisition. So nothing to do with IP, more company law related cooperation. And with a professor, probably because also my dissertation is on international private law, it would probably developed in that direction, international private law, but more also in international corporate law. Yeah.
And law professor, do you have any interest in that still?
I like teaching, but I also like to be in practice. So at the end, I thought, practice is very important, and that's of course you do all day as a judge. I thought it's quite.
So I've been to Düsseldorf a number of times. It's a charming city, a lot of culture, a lot of IP firms. It's not like the Eastern District of Texas here, which is, I think 70% of our cases start here at the Eastern District of Texas. But they are popular in the Eastern District of Texas because they are known to be fast and pro-patentee. What is it about Düsseldorf that gave it the reputation of being the place to go to for patent cases?
Actually, I think it started on the historical background, because before the Second World War, the big cases were dealt with in Berlin. But after the Second World War, Berlin was an island surrounded by the Russians, and so a few specialized lawyers in the field were thinking, okay, we have to move somewhere else. And as far as I was told, of course, long before my time as well. So what I was told is that, okay, they were contemplating either to go to Munich, because this was the location where the German patent office was at the time, or to Düsseldorf, because the heavy industry is very close to the Ruhrgebiet. And then they decided, for whatever reason, to move to Düsseldorf. And with the lawyers that were specialized, the cases came to the Düsseldorf to the Düsseldorf Regional Court, and so the judges started to gain experience, and so it all was pretty much focused to Düsseldorf. Then other places like Mannheim and Munich also had some importance, but I guess this was the main reason why it all started in Düsseldorf. But then when I started to become a patent judge in about 1993, I think second half of 1993, well, you had a few boutiques and a few lawyers in the bigger law firms, but then you could see it growing. You could really see it growing. And if you counted the number of attorneys at law in the field when I started, and then maybe 10 years later, it must have been at least not only doubled, tripled the number. So you see, it was really growing the business, but then over time also the other places in Munich and Mannheim became equally important, and now it's more quite balanced between these three locations.
So when the court that you are at now was thinking of a location in Germany, do you consider Düsseldorf?
I would say probably when you go to a lawyer, they give you some reasons to bring it to Düsseldorf. They give you some reasons to bring it to Mannheim. They give you some reasons to bring litigation to Munich.
And not as a lawyer, but as a judge of the UPC, or as the UPC in looking for a seat. UPC is spread out across Europe. Was Düsseldorf considered to be a location for the UPC?
Okay, yeah. The UPC has 4 locations in Germany, and they are the 3 I mentioned, and Hamburg as well. So you have essentially the politicians understood that the local division of the UPC should be at the same locations where you have the national courts that are dealing with patent litigation.
And so that makes sense.
Yeah, and more or less following these lines.
And is one or more of these considered to be superior to the others?
No, in principle they are the same. The numbers are a bit different, well, it would not be for me to further comment on this.
Okay.
It's at the end of the day, it is for the claimant to decide where to bring the case, and if there's a reason to bring a case in Germany, then they can decide between the 4 locations, okay, then it's for them to decide on this, and it's not for me to comment on this. Yeah.
So going back to your time at the court, you're starting off as a young judge. How do you learn what to do in terms of being a judge, and do you think back on any of your colleagues, senior judge perhaps, in saying, this person was my mentor, I learned not just how to be a judge, but how to be a good member of the legal community from this person?
Yeah, well, you already learn, of course, a bit when you are this traineeship and you stay with the court, so you know how it works. And also the second state examen is focusing on these issues. But of course, then when you are in practice, in the real life, then of course you have a lot of questions, and you turn to more experienced colleagues over time. And then of course it is another challenge when you go to a very specialized panel like the panel dealing with patent litigation. So I learned a lot from the colleagues that were on the panel during that time. And I guess 2 names you may have heard of was at the time the presiding judge was Peter Meyer-Beck, and another colleague that is also well known was Thomas Kühnen. So they were both on the panel, and I was the most junior one, and I learned a lot from both of them.
What did you learn from them, that in particular that you remember, especially about being a leader?
Well, I think it's to understand how it works with technical related cases. That was that was it's not so easy at the beginning, but you learn it from over time. And I think the best way to learn this is really to be on the job, and that is much better than any theoretical articles. But really be in a situation where you have to draft a judgment, and in Germany, the judges always have to draft the judgment, the judge rapporteur. And right from the start, I had to of course draft a lot of judgment, and that was the best way. And then I got some comments from the colleagues on certain aspects, and then you learn from that. Yeah.
So did you find that because the judgments presumably, of course, would be in German, that they did not get as much traction outside of Germany because of the language issue than if an English version were readily available?
Yeah, well, that's a problem. And even if there's an English version available, still the language, the German and the English language are different, not only as to the words, but also the grammar. And sometimes when you read a literal translation of a German decision, it is a bit heavy. And that is partly because maybe the way of arguing of German judges, but it's also partly purely for language reasons, which probably sounds better when you read it in German than if you read the English translation of a German decisions. Yeah, well, we are currently working on this at the UPC as well.
Well, at the UPC, when you draft your judgments, what do you draft it in? What language do you use?
Well, actually, I try to draft in the language of the proceedings. So if it is the language is German, then I would draft it in German, and if the language is English, I would draft it in English. That is, I think it is. Sometimes it makes it a bit more complicated when you always change between two languages. Which happened at an international court, where English is the only language that every judge more or less speaks, having also the advantage that for, I think, all the judges at the moment, it is not the mother tongue. But
so everybody is at an equal disadvantage.
Yeah, it is. Of course, would be better if it were the mother tongue for everyone, of course, for mastering the language. But on the other hand, it gets you all on an equal footing. So that, of course, is also an advantage to it. If it were, I don't know, French or German, then the German judges are, of course, advantaged, which you can see when German is the language of proceedings to some extent. But of course, we also, when the language is German or French, we try to adopt to the situation. But then, of course, the judge with the mother who's speaking the language as a native speaker is, of course, you asked him or her if there's a problem, or you really, when you draft a judgment, well, how to precisely do it or not.
And in the corridor, when you meet your colleagues, when you're discussing a case, what language do you use?
Well, if I speak to a German, it would be artificial to not to speak in German. But if it is, people speaking normally French, at least I try to speak in French. And
when you have a meeting of judges?
Well, in meeting of judges, English, always English. Yeah.
And do you find that when litigants appear before you, because you're a pan-European court, the culture that they bring as litigants reflects their country, and what are some of the interesting observations you might have noticed being a judge at the UPC, having these diversity of cultures and languages coming before you?
Yeah, well, as mentioned, they are all coming from civil law countries, so they have a lot in common, but of course they also see some differences. And well, the lawyers, well, also like the judges, of course, they come with a perspective from that particular jurisdiction. well, the court on the other hand is called the Unified Patent Court. So the idea is that the format should, in principle, be as unified as possible. And for that reason, we published some formats, some templates, in order to align the different approaches. So for example, one question, very formal question, was where is the operative part of a judgment? At the end or at the beginning? In German judgments, it is at the beginning. In French judgment, it is at the end, like in, I guess, most of the countries. But of course, you have to take a decision on this, because it should not be that the local division in Düsseldorf puts it at the beginning and the local division in Paris puts it at the end. That would not be a unified patent court. So we took the decision that is now always at the end.
How do you decide? By majority vote or some other way?
Well, we worked on the templates. Well, we prepared this before the court opened its door in a working group where also some lawyers were part of the team, judges and lawyers, from the drafting committee that drafted the rules of procedure. And then we discussed these kind of things, and then we took a decision there, and this was then adopted by the Presidium. And now the templates are published, and the judges I invited, put it like this, to follow that scheme, and that's the way how it was decided, and now it's always at the end. Yeah.
So I'm glad you talked about the time before the court, because it's helpful for our viewers to also understand the process in forming the court. And you, of course, were a key architect in creating the court and naming the court. So tell us about that process, and why did you decide UPC was the name that you wanted for your court?
Actually, that decision was taken by the so-called preparatory committee. The preparatory committee has or had, it's now the past, it's now the administrative committee. Actually, it's a successor of the preparatory committee, and the preparatory committee, like the administrative committees, as representatives of all the member states, contracting member states, or signatory states at the time, and they decided about the name. So that decision was taken by them. But you can distinguish different phases. So at the beginning there was this preparatory committee, and they started organizing different aspects. One aspect was, of course, IT. Another one was the legal framework. The agreement was already signed but not ratified at that time. The rules of procedure were drafted by this committee, another committee, so drafting committee, 7 people, and they adopted this. They made some changes, but they adopted this. So they prepared the legal framework. Another group was there to prepare HR issues like future training of the judges, but also working conditions. So what about insurances? What about pensions? What about salary? All these kind of things. Code of conduct, also at least how to organize a code of conduct. That was HR, and what other stream? Well, finance was another stream, of course, and then they got to a point where they thought, okay, we are now we prepared a lot of things, so we should now install the Presidium, so the management board. And for that purpose, it was necessary to appoint judges. And there's another committee, an advisory committee, that did a lot of interviews with candidates and made proposals to the admin committee. And the admin committee then adopted the list and appointed judges. And with the judges, but the judges were appointed, but the court was not yet running. So they appointed only a few judges that then also helped to prepare putting into operation of the court, and also the members of the Presidium. And then the Presidium worked for about 7 months to do the final preparation. Again, working on some rules like registry rules or code of conduct as well, together with the advisory committee. Also preparing training for the judges, for the future judges, the colleagues, concerning procedural law, which was completely new for everyone. And then so based on the agreement of the rules of procedure, but another training series on the CMS, so how to deal with the CMS,
which stands for case management system.
Case management system. So the IT aspects of it, because the court is supposed to be an IT court, and yeah.
Is that working well?
Well, well, we will actually. What has already been announced, we will get a new CMS in sometime this year. Put it like this. And well, we heard some comments from inside, from outside, and at some point of time, we decided that we want to have a new system. Yeah.
Well, there's always room for improvement. Yeah, doing this for the first time.
Yeah, absolutely. And this is not the first organization, I guess, that at some point of time decides to have a new electronic case management system.
And of course, that's better than paper. So wherever you are, it's an improvement from the alternative.
Yeah, well, we will see.
Well,
yeah.
Go ahead.
Yeah, and then yes, and then the idea was, well, that we should we agreed to start to have a starting date, the 1st of June 2023, and this was also important because, as you know, those proprietors of European patent that, well, for whatever reason, did not want to be part of the new system, had the opportunity to opt out. And then this so-called sunrise period started 3 months ahead of the starting of the operation of the court. And we also have to organize this because it was quite a challenge. Like always in this kind of situation, you have 3 months time, but most of the filings come in the last 2 weeks.
Just like Texas.
Yes, but that of course is also a challenge for the system, of course. So, and then people were surprised that there were some difficulties. Okay, but somehow we managed to deal with this. And then the next challenge was on day one that a lot of filings were prepared, and everyone wanted to be number 1, number 2 of the cases. That was the second challenge. So it was quite interesting, exciting time around 1st of June 2023. And well, and since then we got many cases. So I'm really content with the numbers of the cases, and we are quite busy. The principle of the court always was that we start with most of the judges being only part-time judges, because it should not be the judges waiting for the cases. It should be the cases come in, and then we may increase the working time of the judges, and that's how it develops. Since then, we have now so many cases, so we increase the working time of the judges, and we also appointed a few more judges, and also increased the number of technically qualified judges.
So, are you full time at the UPC?
Yes, I was right from the start, but I was the only judge at the Court of Appeal. And that on the first, I started to be in the job on 1st November 2022, and I was the only Court of Appeal judge with 100%. And there were also judges at the Court of First Instance 100%, but not many.
So answer this question as modestly or as more immodestly as you would like. Somebody had to be president. How did they decide that you would be president?
Yes, that's explicitly provided for in the agreement, how you do it, or in the statute, and it was an election in the Presidium. So they elect the president. So
Do you have a
the president of the Court of Appeal is elected among the judges of the Court of Appeal. Yeah.
And do you have a fixed term, or is it for as long as you would like?
No, it is for 3 years. So I'm appointed as a judge for 6 years, but of course all open to extension, but for 6 years, and I'm elected to be president for 3 years, and but again open to the 2 extensions. So
Maximum of 2 extensions.
Yes, so makes it as a maximum of 9 years. Yeah.
What if they want to keep an outstanding judge? Do they have the option of doing so?
Sorry, could you ask again?
Let's say that they want to keep you on after the end of your term. Is there a provision that allows them to do so?
There is an age limit. So age limit is 70. So you have to leave at 70, and you can be well, of course, you can be reappointed for a new term, and you can be re-elected as president twice, which means you can be the longest term you can have is all in all 9 years.
Okay.
So it's like the US president, you can also be re-elected only once. So in the UPC, you can be re-elected twice, but it's not for 4 years, but it's twice for 3 years each.
And how did you decide that that was the right amount?
I guess this was decided by the makers of the agreement. So yeah.
Which, didn't you have any say in it?
No, and no, it's a long time ago. So the agreement is from 2012, and signature, so it's a long time ago.
So as president, you are also a manager of your judges and the court. How do you mediate or arbitrate, settle the differences between your colleagues, between different groups in the court that have a view of going one way compared to the other way?
Yeah, well, the body that deciding this, so the management body, is the Presidium, and I'm the chairperson, but I only have one vote in it, and it's composed of 7 members, and also, of course, including the president of the Court of First Instance. And so, when it is mainly an issue of the Court of First Instance, I think it is more for her, so Madame Butin, Florence Butin, to deal with these issues. If it is more a Court of Appeal matter, then I would consider myself to be a bit closer to the issue. If it is of general importance for the court, then it of course would be the Presidium or myself to deal with the issue. So if the more important it gets, the more the whole Presidium will get involved. And if it's a day-to-day business issue, then I decide myself.
So in a constitutional democracy, say like the United States, you have the judiciary, you have the legislature, you have the executive, and each is supposed to act as a check and balance to the other. In a system like the UPC, where you don't have a legislature, so to speak, or an executive, how do you have that balance? Or is that even considered a relevant goal for the UPC?
We have a legislator, that is the administrative committee. So they are they can decide on amending, for example, the rules of procedure, on all the rules you can find on our website. It's mainly in their hand, but we have a budget committee as well. They decide on the financial aspects. We have an advisory committee. They give advice in particular with regard to new appointments. and with regard to training as well. So we have these bodies, and the Presidium is mainly the management. So, well, what about IT? How to organize IT? Also, increase of working time of the judges. It's also, but not appointment, only increase of working time of the judges. And there, the criteria in principle is, well, you have a lot of work in your division, and then that gives reason to increase your working time. That is essentially the idea there. And we also organizing training events, which are very important because it gets all the judges together. So normally once a year we have this training event, and yes, and a lot of other issues that are coming up.
So in terms of addressing judicial misconduct, how would a litigant or member of the public or member of the court seek accountability for a judge that has been accused of judicial misconduct?
Yeah. So, well, misconduct, of course, is theoretically, of course, possible and maybe also practical, even though hasn't been any case up to now. But the issue has been more broadly discussed with regard to technically qualified judges, and because some of them, actually the majority, are also in private practice. And then, of course, the issue of conflict of interest comes up. And there was expressed fear before the court was up and running that that might not be dealt with in an appropriate way. But together with the advisory committee, the Presidium set up, prepared a code of conduct that then finally was adopted by the administrative committee, and that, I think, quite clearly draws the line what is possible and what is not possible. So, for example, one important decision that was taken in this code of conduct is that when you are a technically qualified judge in the UPC, you cannot be a representative in the UPC. So you cannot be a technical judge on Monday and the representative of a UPC case on Friday. That is not possible. You can be a representative in the EPO of a case as a patent attorney. You can represent a case when you are a German patent attorney, for example, in the German courts, provided this is admissible there, but you cannot be a representative in the UPC. So that draws a line. Of course, then on a day-to-day business, of course, a claimant is there, a company, and then the technically qualified judge has to be allocated to the case. And then, of course, the question comes up, is there any relation between the judge and the company, the party of the case? And then, in essence, the patent attorney or the technical judge that is at the same time a patent attorney has to do a check, but it's like the normal check you do as a lawyer or as a patent attorney when you get offered a new mandate, a new case, and then the judge, technically qualified judge, responds, okay, I have no relation whatsoever. Also, in my law firm has no relation to that party, and it's green light. They have some relation, then it's probably a red light. And then there are some cases a bit in between, yellow light, and then the president, a court of first instance, if it's a court of first instance case, me, if it's a court of appeal case, has to decide, okay, I allocate the judge to the case or not, or what, in case of doubt, could also be an option to disclose it to the parties and then ask them, do you see a problem there or not? And then, depending on the statements, decide to allocate or not to allocate the judge. So that is probably the most practically relevant situation. But up to now, fortunately, that system works pretty well, and we had no recusal because of conflict of interest later, when the judge was already allocated the case, and then this comes up. But we didn't have the case at the moment in that regard. We probably have in the future at some point of time. You probably cannot avoid this, but it's not a big issue at the moment.
Thank you. So 2024, you were named to IP Hall of Fame, one of 3, I think. And it's sort of seen as a global states leader for IP, not just for the fantastic work that you're doing in Germany or in Europe. Help us understand what some of the challenges are where you are sitting looking at the global landscape for IP, and how do you see your court contributing to addressing some of these issues?
Well, I think, well, my perspective is that of a patent judge. So I'm probably not so much focusing now on trademarks or copyright aspects of it. And the intriguing thing with technology is, I think that is a moving target, because it's constantly developing, and you have to think about how these new developments reflect the application of patent law.
And so there was just one new development today. Do you want to talk about that?
Yeah. Well, maybe before, if I have a few more minutes before I get there.
Yes.
Just back in time in the late 90s, there was the development technology from mechanical solutions to software solutions. And it was really interesting to see how certain patent claims, when they were more defined according to their function rather than to structure, also applied to software solutions or not. It was really a bit the way how the patent attorney originally drafted the claim to see whether it still covered also software solution to the problem or not. That I think was a very interesting aspect at the time because of the development of technology. And nowadays, of course, one interesting aspect is AI. How will this influence the practice of patent law? I've seen a lot of conferences and already asking questions about should we change the law. I think we at least we are not yet there. You never know what's happening in the future, but I think we are not yet there. When it comes to ownership, I think we already have the famous Davos case in almost all jurisdictions all over the world, and the answer is almost unanimous. It can only be a natural person or a legal person, but not an AI, which I think it was pretty obvious to be. And then the other question is, okay, how can you protect AI? Yeah, well, it is software. Like you can protect software. You cannot protect software as a patent as such because it is a computer program. But as soon as it has effects in the real world, in the physical effects, chemical effects, whatever effect in the real world, it may be the subject matter of patent protection. I think that is, and that essentially would also apply to AI software solutions, to my understanding. And then, of course, it's a question of to what extent does it influence inventive step? And there, I would tend to say, at the moment, I would consider this as a tool, maybe a very sophisticated tool, but still. There is no AI, at least to my knowledge. I'm not an expert, but what I'm told is that AI decides today, now I make an invention and starts running. There's always a human being behind it and gets the whole process started. And I guess you would consider that person then endowed to be the inventor. And then the question is, okay, did it need some more than an average person to get to the invention? Then it is either inventive step or not. Was it obvious or not? So that is more or less the concept there. So that is, but as you I think you alluded to, that's not only in the technology we see developments, but also in the legal field. And yes, I think another important aspect that is very important, and will be very important is the cross-border aspect and the standardization aspect. And in that regard, how to deal with essential patterns. At the moment, I think all over the world, it is the courts that deal with essential patterns. But in Europe, the Commission had an idea to find a friend determination process in an authority in Alicante. But we now learn that at least the draft that has been put forward to the public has been withdrawn, and I welcome this development, because there were some unsolved issues, to put it like this, and one in particular was that access to justice was to some extent put into question. Well, the system, so it was good that it was withdrawn.
Thank you. There was a technical issue briefly, but I'm back. So last question is just to think about your role as a leader, both in your organization, personally, and globally. What reflections or thoughts do you have for our viewers in terms of thinking about their own leadership journeys?
Yeah, well, I think it's important to be open to these kind of developments, and well, to reflect on these developments, and then to try to find adequate solutions. I think it's important, as we are in a global world, to some extent respect that IP rights are national rights. So I think it's not a good idea if courts in one jurisdiction get cross-border to some extent, but stay in your own jurisdiction, but always reflect on what is on what the other jurisdiction do. Harmonization is very important, I think, for the courts. And yeah, well, have a kind of standardization of the application of the law in the different jurisdictions. And I think that would be very welcome by the users, because the users expect cases to be decided not differently in different jurisdictions.
Thank you very much. Have we covered everything?
Yeah, I think so. Yeah, I think so.
Well, thank you then for joining us on this episode of Profiles in Leadership, and thank you for your service. I look forward to seeing you soon.
Yeah, it's a pleasure. I look forward to seeing you at Fordham, I guess.